Hello, everyone. I'm Jim Tankulo, a partner in the Chicago office and a member of the firm's litigation and international arbitration practice. Having trouble with the slides already. I have practiced litigation for over 35 years. In addition to numerous court trials, I've tried significant energy, mining, and commercial international arbitrations. Joining me today is Miles Robinson. Miles is a partner in Mayor Brown's London office and also a member of our firm's litigation and dispute resolution practice, and he is also an international arbitration specialist. Before we begin, I have a few housekeeping announcements. First, as we go along, we hope that you will ask questions by using the Q&A panel on the right side of your screen. We will make every effort to answer questions toward the end of the webinar. However, if we are unable to answer your questions during the presentation, we will follow up with you directly once the webinar has ended. Second, regarding the CPD and CLE credits, we will be providing an alphanumeric code at some point during the presentation. In order to receive credits, participants must record this code on the virtual sign-in sheet that was emailed to you with the log instructions for today's program. Finally, I have one caveat. The views that Miles and I express today are our own. It should not be attributed to our firm or our clients. With that, let's get started. Miles?
Thanks, Jim, for that introduction. As Jim said, I'm a partner in Mayor Brown's London Litigation and Dispute Resolution Group. I've been a litigator for over 20 years, which is rather paltry compared with Jim's 35. But my experience spans a wide range of commercial litigation and international arbitration matters across a number of industry sectors, but particularly consumer goods, manufacturing, media, energy, and IT. So when Jim and I first talked about doing this webinar, our aim was to provide a dispute resolutions lawyer's view of the pros and cons of the two most well-known dispute resolution methods. This is intended to be a relatively high-level summary of what are quite complicated issues. So I apologize in advance if what we say is obvious or already understood by everyone on the call. Our hope is that you will come away from this webinar with perhaps one or two new issues to consider when you're thinking about dispute resolution methods, and that you will put consideration of the dispute resolution clause slightly higher up your agenda when negotiating commercial contracts or transactions. We're delighted to see that there are people on this dialing in to this webinar from all parts of the globe, and as such we've tried to avoid making the content too specific to any particular jurisdiction and stick more to general principles. So why is this topic important? Why do we think it's important? In our view, every transaction is different. And that means that the method of dispute resolution chosen for each transaction or contract should be considered on its merits. One of the key reasons that we see for selecting your dispute resolution method with care is that it provides you with predictability. In particular, knowing where you are going to resolve your dispute and therefore knowing what process is going to be undertaken is critical. Now, obviously, everyone hopes when entering into a transaction or a contract that it will not end in a dispute. What does increase the business risk, in our view, is that if the dispute that you have ends up being heard in a forum that is unexpected and therefore less predictable for the business. Another key factor is consistency. While I've said that one size does not fit all, it does make sense to have a set of guiding principles when deciding which dispute resolution method and forum to choose. Generally, we would suggest that you tend to choose from a relatively limited menu of options for your usual day-to-day business, which should help to enhance your business's ability to for instance, retain consistent counsel across the jurisdictions in which you operate, and to adopt and maintain internal policies that are broadly consistent with the likely forums within which disputes will be heard. So we're thinking about things like, for instance, policies for retention of documents to fit in with the jurisdictions where you're likely to be litigating or arbitrating, and the approach to legal privilege. The final point on this slide is enforcement. There's nothing more frustrating than succeeding in a dispute only to find that you can't easily enforce the hard-won judgment or award. Selecting the appropriate dispute resolution method may enhance your ability to enforce a successful outcome. So on this next slide, we've listed some of the main dispute resolution methods, starting with the two on which we're focusing in this webinar. So for those that are listed after litigation and arbitration, each of these methods has its advantages and disadvantages and may be used in parallel with litigation or arbitration, or indeed instead of them in some cases. But before we get to the meat of the webinar and talk about litigation and arbitration and the comparison between the two, I'm going to offer some brief thoughts on the other methods that we've listed on the slide. Starting with mediation. I'm sure it's a method with which most of the callers into this webinar are familiar, but as a refresher, this is nothing more complicated than a facilitated negotiation where an independent third party seeks to broker a deal between the parties in dispute. The key thing is that the mediator does not reach a decision or impose a solution on the parties. The parties can choose to reach a resolution or not. They can walk away if the deal on the table is not what they want. As such, it's a method that does need to be used in parallel with or in addition to a dispute resolution method where a decision is reached or imposed on the parties. In terms of when mediation is most effective, again, no hard and fast rules for this, but we often find that mediation can be most effective when the issues between the parties are reasonably clear and there has been some progress made in the chosen dispute resolution process, whether that's litigation, arbitration, or something different, before mediation is attempted, as it does tend to mean that the parties are more focused on resolving the dispute than they might be at an earlier stage, not least because they've seen that there would be a fair degree of pain in progressing the dispute much further. The next two methods that we've listed, evaluation and expert determination, involve a third party being contractually required by the disputing parties to reach a view on the dispute. This can be done on a binding or a non-binding basis. Where we tend to find these methods to be effective is in resolving technical or relatively small disputes during ongoing contracts, given the risk that you run with these methods with a rough and ready decision, which might not be based on a full consideration of all the issues. The next method listed, DABs or Dispute Advisory Boards, is a method that's commonly used in construction or large outsourcing contracts, and again can be a very effective way of resolving disputes quickly in a situation where the parties have an ongoing relationship and cannot allow a dispute to fester or hold up a project. Next point on the slide is escalation clauses. These are where the parties are required to go through a series of steps before they get to either litigation or arbitration or some other method. This can be a good way of getting the parties to focus on the dispute and to have the key stakeholders from either side meet or discuss to reach a solution before the dispute escalates and threatens the relationship. Finally, I've mentioned hybrid options, hybrid clauses. These are clauses whereby you have any number of permutations of the above methods that can be used, whether in parallel or in sequence, or indeed you could have options where you use different types of dispute resolution methods for different types of disputes within the same contract. All very sensible and workable if you thought it through in advance. However, one note of caution: dispute resolution clauses can be extremely complicated, and while this comes from absolutely the right sentiment, namely to have given the appropriate structure some proper thought, there is a risk that the more complex the clause and the more steps that the parties are required to undertake, the parties may not have the resources to operate all of those steps efficiently or in accordance with what is required in the contract. This is particularly the case where you have steps involving senior executives who are required to meet and discuss matters within a very tight timescale. If this process isn't followed, this can cause a great deal of frustration on one or both sides, which defeats the object of a well thought through clause. Sometimes simplicity can be best. So moving more on to the meat of the discussion. In the next couple of slides, we've set out some points which are commonly considered to be advantages of choosing court proceedings over arbitration. However, I would add a word of caution here. These are generalities, and much depends on the dispute in question, whether you're the potential claimant or the potential defendant, how strong your position is in the particular dispute, the commercial positions of the parties, and frankly, personal preference. Moving through to the first point, I think it's generally the case that you're more likely to get a decision based on the law when you're in court, which in theory should make the outcome more predictable, or at least the principles on which the outcome is based should be more predictable. When you're in common law jurisdictions such as the UK and the US, these have precedent systems which, again, in theory, should add to predictability, although in practice can often create more scope for argument. Second point that we've identified is the right of appeal. As we'll come to later in the presentation, there are generally very limited rights of appeal from arbitration awards, whereas most court systems have processes for first and often second appeals. This is generally perceived to allow an escape route from bad decisions and to help ensure that first instance judges are focused on making a law or precedent-based decision. But as with all of these points, there is a potential downside, which is that it can push the timescales within which a final decision is reached out quite significantly, depending on the jurisdiction. Next point really depends on your negotiating position. If you are in a strong negotiating position, you're able to choose your home or local forum or another familiar forum. That may prove to be an advantage over your opponent because of your familiarity with local systems and procedures. Point 4. The threat of court proceedings can be a very effective tool in resolving disputes at an early stage, perhaps more so than the threat of commencing an arbitration, because of some of the factors mentioned here, in particular the risk of publicity. Point 5 mentions strict rules of evidence. I'd perhaps broaden that slightly to talk about procedural rigidity of court processes. Again, this very much depends on your perspective. It may or may not be a benefit depending on your situation, but it does help to ensure some level of certainty and predictability on the process, and also ensures that both parties are held to the rules of the court generally, as opposed to the greater flexibility that can sometimes happen in international arbitration. Point 6 is another one that can weigh both ways, and is linked to an earlier point, the threat of litigation, namely that litigation is played out in a public forum generally, which can be a real incentive to force the parties to the negotiating table to avoid that kind of public scrutiny. Of course, the importance of this factor will depend on your business's approach to disputes. I've certainly seen some businesses who actively want to be seen to be enforcing their rights, as they see a real business benefit in doing so. Certainly not everyone's approach, but I've certainly seen it. The next point is another nuanced one, and it really will vary significantly between jurisdictions. So in common law systems, parties are likely to be required to disclose a much broader scope of documents than in international arbitration, which has the benefit of ensuring a more forensic consideration of the issues. Also, the fear of having to disclose unhelpful documents, and indeed the potential costs and disruption of the process, can again force the parties to the negotiating table earlier than might be the case in arbitration. Generally, also, court proceedings allow the possibility of seeking documents and evidence from third parties, which can be problematic in arbitration, and Jim will talk about this topic a little bit more shortly. Again, as with all of these points, there's a downside. The scope of disclosure, particularly in common law jurisdictions, does generally increase the costs of litigation beyond what you might see for that phase anyway in arbitration. So moving on to point 8, interim relief. Although I would say that international arbitration has made great strides in the past few years in introducing better procedures for the parties to seek effective interim relief, it remains the case that seeking injunctions and the like is generally easier and more effective through the courts, both in terms of speed and a real ability to make the sanctions stick. The next point is probably more a claimant's or a plaintiff's point than a defendant's point, in that the court process is non-consensual. So once the process starts, the parties are locked in, with perhaps less scope for delay than in arbitrations. Again, it can cut both ways. The next point, point 10, is one where we could probably devote a whole session to this topic in terms of identifying local factors in particular court jurisdictions. Again, there are pros and cons with each of these local factors. So, for instance, there are benefits and disadvantages to jury trials in the US, and the quality, efficiency and impartiality of the judiciary and the judicial processes vary substantially between jurisdictions. Next point, point 11, really does depend on your standpoint. If you're interested in progressing a dispute and holding a party to the timetable and to the rules, the availability of real sanctions for non-compliant parties can be a real benefit, as it can avoid some of the game playing that does go on in arbitration proceedings. Equally, of course, if you're the party who wants to delay and obfuscate, then you'll have much less scope to do so in most court proceedings. Point 12, probably more relevant for common law systems, namely that a decided case will provide a precedent for the future, although in most jurisdictions there is at least some value in previous favourable decisions. Moving on to point 13, which is enforceability. Jim is going to mention this as a benefit for international arbitration, and I certainly would not disagree, but I would also say that in some cases court judgments can be as easily enforced as arbitration awards. So for instance, within Europe there are very settled and efficient systems for recognising judgments from other EU member states. However, you do have to be much more careful in assessing the potential enforceability of a judgment than with arbitration. The final point in this section, it may be the case that your dispute involves more parties than your immediate opponent, and most court systems allow additional parties to be brought into a set of proceedings so that the issues arising from one dispute can be heard and resolved in one place and one set of proceedings. This is not the case with arbitration, which is essentially a contractual process, so only the parties who have agreed to participate can be forced to do so unless there is later agreement on all sides to do so. So I'm going to hand over to Jim now, who's going to put the case for international arbitration and the benefits of that over the court processes.
Thank you, Miles. So why might international arbitration provide a more appropriate procedure for resolving disputes? First, it has long been viewed that international arbitration can provide more certainty to the parties when their dispute will be heard by individuals who are more expert or experienced in the industry or business world than a judge who may have absolutely no experience in such industry. Second, arbitrators may be more likely to provide a result that properly assesses the equity of a result. This can be an advantage, particularly in a relationship that is expected to continue beyond the dispute. Of course, it may also be a disadvantage if a party or parties wish for a result based on a strict contractual or legal basis. Again, it cuts both ways. Third, the traditional perception has been that arbitration, particularly international arbitration, can be less expensive and quicker to conclusion. There are circumstances where this may not be true. Some courts have greatly improved their efficiency in docket management. There may be a difference between Miles and practicing in the UK and in Europe and us in the US, but I would say there's probably more ability to delay in court than there is in an arbitration. You don't have the sanctions, that's true, but there are all kinds of ways to get extensions, and judges frequently will grant them. And nonetheless, if your dispute is likely to be heard in federal court in the U.S., civil cases are frequently delayed because federal judges must give priority to criminal cases under the Speedy Trial Act. In considering whether to choose a court for dispute resolution, the parties should then consider or consult with litigation counsel who are familiar with that particular court system and weigh that against an international arbitration. Fourth, arbitration awards are less likely to result in crazy numbers than a jury might award, the risk of a runaway jury. Fifth, I would say that international arbitrations offer the ability to choose neutral territory and to avoid home cooking. It is often difficult to choose a neutral court if that court has no interest in the dispute. But in an international arbitration, you can choose a site for the arbitration, and in almost every place, that site the choice of the forum will be honored. This is particularly important for projects where a host government or court system is known to favor the local party. One question that we've received is, what do you do when a customer, say a national oil company, insists in using local arbitration in their native language. Some countries, this is where you're going to have to worry about the home cooking. Some countries have laws that require particularly for minerals or natural resources, that the arbitration does occur in the home country, and you may not be able to avoid that. But I would say that's probably a lot better to have an international arbitration than to have be in the home country's courts in most cases. A lot of it just depends. If there isn't a court or a law requiring the arbitration be in that country, then you may be able to argue on a basis of protections that you can try and have outside of the country. But I would think when you have that problem, again, you may unfortunately just have to be in the home country. And there is what you want to do in the form is make sure you're going to have arbitrators that are not all of the same nationality, and it may make it difficult to find people who speak the language if it's a rare language. But that I think still argues for international arbitration over agreeing to court there. Now, another thing is, while there's strict rules of evidence that can be beneficial, as Miles said, arbitrators are not bound by them. Consequently, arbitrators are able to hear evidence that might be excluded in a court, and good arbitrators will give the evidence the appropriate weight. Seventh, there is a possibility of confidentiality, which can be very valuable to the parties. In an open court system, this is almost impossible. And then eighth, a topic we'll discuss in a little more detail in a few minutes, there is limited discovery in international arbitration, and this can limit the expense of the dispute resolution. Ninth, and perhaps the most important reason that people choose international arbitration is that enforcement of an arbitration award is more likely than a foreign court judgment. This, what I would say, is bolstered by the 1958 New York Convention, which is the formal name is the Convention on the Recognition and Enforcement of Foreign Arbitral Awards. It provides a very valuable basis for the enforcement of awards. 157 state parties are signatories to the convention, and foreign court judgments are less likely to be honored in those countries, with the exceptions of places like Miles mentioned, maybe in the EU, where there is a treaty. But in the end, what you're looking at is the New York Convention offers an overarching treaty for the enforcement of international arbitrations. 10th, and for many, if not all of the reasons I just spoke about, the opposing party may also prefer international arbitration to the alternative of the other party's home court. In other words, it might make your negotiations easier, or the fallback position is let's go someplace neutral. Now, as I mentioned, discovery is limited in international arbitrations. The significance of this is probably most important in deciding whether to go to a U.S. court, where discovery is time-consuming and very expensive, or international arbitration. While it was long considered one of the great advantages of international arbitration that discovery would be limited, there are a lot of complaints over the last decade or so about the Americanization of international arbitration and the influence of U.S. counsel in pressing for more discovery. While this could be a lengthy topic for another day, suffice it to say that in my experience, extensive discovery is still highly disfavored in international arbitration. Document exchanges between the parties are more frequently ordered, but many arbitrators will apply the International Bar Association, or IBA's, rules on the taking of evidence in international arbitrations. They have I recommend these rules to anyone if they're considering international arbitration, and considering whether you should consider whether you'd like to explicitly include an agreement that the IBA rules should apply. Now, one important issue to consider is that third-party discovery is often very difficult, if not impossible, to obtain in an international arbitration. The majority rule in the U.S. is that the Federal Arbitration Act and other statutes do not permit compulsory third-party discovery, but that evidence from a third party may be compelled, subject to some limitations, at the actual hearing. In other words, you can subpoena somebody to show up at the hearing, but you can't get a deposition or document discovery on them. You can subpoena them again to bring the documents with them to the hearing, but that's also subject to geographical limits and such. Some states do allow this, and that's the case where if you're looking then again to which law to apply or form, you should consider whether or not you want third-party discovery in the U.S. Now, in terms of e-discovery, this is an extreme, I think any client out there who's had to go through this, you'll know this is could be a very expensive process, and unfortunately, e-discovery has infected international arbitration. But depositions are very disfavored in international arbitration. And in many, if not most international arbitrations, witness direct testimony is presented by written statements in advance of the hearing. And these are considered by many to be a worthy and cost-effective substitute to depositions. Now the parties, because arbitration is a creature of contract, parties can also limit or provide for limited discovery or depositions in the contract. So in other words, you could say, we want 3 depositions or something like that if you think it's going to be important. Miles, so how does discovery or disclosure work in England in international arbitrations?
Thanks, Jim. So my experience of arbitrations where the seat is in England, the governing law is English, and the arbitrators are English lawyers, is that it is often the case, or can be the case, that the procedure followed in the arbitration, and disclosure in particular, can be more similar to English court proceedings than the traditionally more limited scope for international arbitration. So it's, I think, increasing trend, I would say, to have more document disclosure than less here. You mentioned third-party disclosure and evidence. You know, broadly, the position is the same here in the UK. It's very difficult, if not impossible, to obtain disclosure from third parties in arbitrations, but third-party witness evidence can be obtained in certain circumstances. And just a word about how the English courts are approaching disclosure. It's very much recognised that this is a process in English litigation which massively increases the costs of the process, and there are numerous proposals being considered at the moment whereby the scope of disclosure can be cut down to make the process more manageable, and I think that is definitely coming. So I think we will see a real shift over the next few years to much more limited and perhaps more arbitration style disclosure in England. So back to Jim for appeals.
So if parties have decided they don't want a jury trial and want to limit discovery and all the costs and inconveniences, which group should they? Okay, sorry, flip the slide. So if the parties decide they don't want a jury trial and want to limit discovery and all of its costs and inconveniences, then why roll the dice on getting a judge who may have no knowledge of your industry or who might be sitting because of a political appointment or election and not on objective merit, when you can have a say in who sits on the arbitration panel? The main answer to this question, as Miles discussed, is that one of the significant advantages going to court is that there is a right of appeal. Before reflexively choosing court because of the right of appeal, the parties should consider how valuable that appeal right truly is, and that may depend on the jurisdiction of the court that you would be in. What are the standards of review and appeal in that jurisdiction? How much deference is going to be given to the trier of fact under the law in that jurisdiction? In other words, how likely is it that a factual determination at trial will be overturned? And in judging that, you can decide whether your dispute will be more likely one that's going to turn on law or fact. Now, admittedly, that may be very hard to predict at the beginning, but sometimes the circumstances of a project or a long-term relationship may make that issue more obvious, or the decision on that issue more obvious than not. Now, generally, legal errors by a court can be reviewed and overturned, and legal errors by an arbitration panel are rarely overturned. There are some limited court reviews in an international arbitration under the New York Convention. Is a cite to Article 5 of the New York Convention, under the UN's UNCITRAL model law for arbitration, which is Article 36 of that, and the U.S. Federal Arbitration Act, 9 U.S.C. Section 10, and then under the UK Arbitration Act, Sections 67, 68, and 69. And Miles will talk just briefly a little bit about those right now.
Yeah, so from a UK perspective, the Arbitration Act provides three main rights to appeal. These are that A, the tribunal did not have jurisdiction to hear the dispute, B, that there was a serious irregularity affecting the tribunal proceedings or the award, or C, that there was an error on a point of law. However, many institutional rules will preclude an appeal on the last of these rights, the point of law. So in practice, the appeal rights from an arbitration are likely to be much more limited. It's also worth noting that even if you can mount an appeal in the English courts, the general approach is to try to uphold arbitration awards rather than overturn them. Jim, back to you for the various international arbitration bodies.
Yes, thanks, Miles. As a note, some studies I have seen show that in the U.S. arbitration awards are vacated in less than 10% of the cases, which might give you some sense that it's rare to have an arbitration award overturned. Now, slide I showed earlier, there are a number of international arbitration bodies, such as the International Chamber of Commerce, or ICC. The American Arbitration Association has its own international group, which is the ICDR, or International Center for Dispute Resolution. The LCIA, which is the London Court of International Arbitration, has a long and prominent history and a set of well-established rules. And there are newer regional centers that have come into existence in the last few decades, such as the Singapore International Arbitration Center, or SIAC, and the Hong Kong International Arbitration Center, or the HKIAC. There are many others that are propping up in other regions of the world, particularly some of those in the Middle East. And parties can also choose ad hoc arbitrations. That is where there is no governing body, in which case we recommend that the UNCITRAL rules or some other rules such as the CPR, which are the rules of the International Institute for Conflict Prevention and Resolution, be adopted. These rules then for the arbitrators have, and for the parties have you at least have a rule basis for how the arbitration should proceed. In the old days, I will say, I've had contracts where there are no rules at all. I think this is rarer and rarer, and that can cause a lot of uncertainty. So we definitely, if you want to save money by going into ad hoc arbitration way, we do recommend that you cite the rules such as the UNCITRAL rules or the CPR rules. Now, we are often asked which way to go. One is if you want to do ad hoc, it's obviously cheaper. You're not paying any fees to the body, but having an experienced arbitral body for appointments, reviews, and administrations can justify the international cost, particularly in the larger arbitration. And so if you decide to go with a arbitral body to oversee the arbitration, we often get the question then, so which one? And that, again, depends on a lot of different factors. Sometimes it's just comfort and familiarity of the parties. It also may be regionally based, but there are advantages and disadvantages to some of them. The ICC, for example, has a procedure where its court, which is a group of arbitrators, does a limited review of awards before they are issued. The ICC also has terms of reference procedure where the issues of the arbitrations are well defined in the document at the beginning of the process, and that court then checks to make sure that the issues that were in the terms of reference have been answered. Some other bodies, such as the ICDR and JAMS and other U.S.-based and the CPR, have an optional appeal process that can be agreed to in a contract. So you're not in court, but the appeals are reviewed by other arbitrators. Now, one thing you should note, especially in the U.S., is you cannot contract to have an appeal in the courts beyond that, which is that expands the grounds of appeal from those that are in the Federal Arbitration Act. That decision in 2008 is Hall Street Associates versus Mattel. So in other words, parties frequently used to say, yeah, we're going to have arbitration, but if we don't like it, we can appeal, and the grounds for appeal will include things that were beyond the limited FAA rules, and the Supreme Court said, no, you can't do that. There's no jurisdiction of the courts. Now, I already mentioned the IDA rules on the taking of evidence. I would point out that in dealing with foreign governments and other international contracts with at least agencies of foreign governments, there are circumstances where the International Center for the Settlement of Investment Disputes, or ICSID, which is a part of the World Bank, can provide a forum. Such disputes usually arise under bilateral investment treaties or sometimes multi-party treaties. This is a good backstop for a number of disputes that you could have if you're dealing with a national entity. I'll quickly address the issues on choosing an arbitral panel. In complicated cases, I firmly believe 3 heads are better than 1. In smaller cases, cost-benefit analysis frequently result that 1 arbitrator should suffice. In fact, the ICC just modified its rules last year so that in smaller cases under $2 million, even if you choose for new contracts, even if you say we want 3 arbitrators, if it's under $2 million, the ICC can order that it's just 1 arbitrator will decide it. I just saw a debate on this. Most clients like this because they see it as cost effective, and if it's that small of a matter, they'd rather just get an answer than spending a lot of money to get the answer. Another thing you can do in an for your arbitration panel is require specialized expertise or experience of an arbitrator. They're saying you want somebody who's, in your business. Sometimes you say, I want a commercial person. In international arbitration, now the general rule is that the wing or party-appointed arbitrators should also be independent and neutral and not advocates for the party that appoint her or him. In the past, particularly here in the U.S. in AAA arbitrations, the wing arbitrators were seen as advocates. That has been disfavored long in international arbitration, and that practice is actually disappearing in the U.S., I would say. While there are many considerations in selecting a wing arbitrator, in other words, your party-appointed arbitrator, one of the most important ones, in my opinion, is whether the arbitrator plays well in the sandbox with others. You want an arbitrator who's a cooperative soul, one who's likely to command respect of the other arbitrators by her or his ability to get along, to argue persuasively without insult and or arrogance. One who's really going to help to build the process, because what you're really looking for in there often is to try and convince the presiding arbitrator or the chair. And that's the influence, I think, that everybody should be looking for when they appoint an arbitrator. Now, what about when you have the choice, or your arbitrator is helping you with the appointment of the chair? One of the things you want to look at is who's on the other side, who's the other side appointed in the wing, and how likely is the person you're considering to be the chair, how likely is that person going to be intimidated by one of the wing arbitrators? And those are considerations. You know, what's the stature, what's the experience of that, of the chair? I would finally say that in your cooperation, you'd rather have a say in the selection of the chair or the sole arbitrator rather than having the appointing body choose the chair. So if you're drafting clauses that recommend that the parties at least try to choose the chair, frequently you may, particularly in disputes, you may run into the other side won't agree to anything that you want, but that in my experience is becoming less and less as people start to see that they'd rather have a voice in choosing the chair. So Miles, now we've chosen a forum, how should we go about choosing the governing law?
Yeah, thanks, Jim. So this takes us to our final topic, which is to give some thought to the issues at play when choosing the governing law of a contract, whether you've chosen litigation or arbitration. There are any number of options or justifications that you could use, whether it's the site of the project, the law of the jurisdiction of one of the parties, or the law of the financing entities for the project, or whether it's easiest just to choose a neutral law. No hard and fast rules here, although what I would recommend is that a well-developed system of law is preferred because of predictability and wider availability of appropriately qualified counsel, arbitrators and experts. I'd also say that if possible, the law of the forum in which the dispute is being heard is the preferable choice, particularly if you've chosen court-based litigation. Even though courts in particular will and arbitral panels, of course, will generally respect the choice of law made by the parties, there can be a downside. So an example is if you seek to have an English court apply German law to a contract, the English court will happily do so, but you do have the challenge of linguistic differences as well as a crossover between civil and common law principles. And where you have those types of factors, you decrease predictability. Another more general consideration, whether to choose a civil or a common law system to govern your dispute, that's often going to be dictated by the experience of the parties, indeed might be influenced by the parties who are financing the transaction or the project. But again, you've got the sort of fairly obvious distinction between different types of disclosure requirements, likely to be much wider in the common law system than a civil law system, use of precedent, which you'll have in a common law system but not necessarily in a civil law system, and various other factors. I have said earlier that the courts will generally respect the party's choice of law. That's right. but it's not absolutely always the case. So you should be careful when choosing a law that is not obviously related to the dispute or the parties. Courts sometimes can be uncomfortable about that kind of choice, particularly if there is an indication that the parties have made that choice to avoid particular consequences arising out of the choice of a more natural law to govern. There's much less of a consideration in arbitration, although it can still be an issue. So on this slide, we've set out some of the key factors to bear in mind. Some of these are mixed factors with the choice of forum. Need to think about things like how procedural issues work, how legal fees are dealt with, is there a loser pays system or not. Think about the quality of the judiciary and the case law system. Think about whether the courts and the legal systems are friendly to plaintiffs or to consumers or to businesses, and also think about timescales. How efficient are the courts? I've mentioned previously the risks of choosing a law which is different from the forum, but another consideration, particularly where you have a suite of documents, is whether you should have the same method of dispute resolution and law for each of the documents. And if not, and there may well be very good reasons why, for negotiating reasons, that's not possible, you do need to think about how those documents are likely to interact. So, for instance, is there a risk of conflicting decisions? Are you going to need to interpret different documents under different laws in different jurisdictions? That's not to say that you shouldn't have different dispute resolution provisions and governing laws. It's just that you should bear in mind that it is going to create complexity, and it might hamper your enforcement of contractual rights at a time when there is a dispute and at the time when you want to ensure that you can enforce. So, on to the next slide, please. So, to summarise on this topic, our view is where possible, select a sophisticated body of law. Try to ensure that you select a law or a legal system that you're comfortable with. If possible, think about the types of disputes that are likely to arise from your contract. So is it better to have common law or civil law applicable, with the differences in the precedent system and disclosure regime, to name but two? And then in terms of the jurisdiction to select, there are bound to be local considerations at play. Jim's going to pick up some of these from the US and to conclude the presentation.
Thanks, Miles. So, as Miles said, if you're choosing a law from the US, it's helpful to consider the experience of the US state law and jurisdiction. Certain US jurisdictions are well-versed in types of disputes, and the published opinions may be of sophisticated judges that could have a significant influence on your case. For example, New York law and courts are well established and have sophisticated principles in financial and commercial law. Delaware law is established on corporate law, and if you have an oil and gas dispute, you might want to use the law of a producing state such as Texas, which can be much more developed than one with no history of oil and gas production. So in conclusion, we think that when negotiating dispute resolution and choice of law clauses, a party should consult with its favorite experienced litigator to help and guide it through the decision, because numerous issues bear on the choice of dispute resolution method. The key consideration to look for is predictability of process, outcome, and enforceability. Practicality is important too. Parties may not have the resources to operate complicated, multifaceted dispute provisions in practice. Beware also of conflicting dispute resolution provisions in a suite of documents. Particularly be careful when you're choosing international arbitration that you don't have conflicting arbitration provisions that could render the clauses unenforceable, and then you find yourself in a court where you didn't want to be. And now consider maybe the most important advice in some ways is consider the issues early. Leaving it until the end of the negotiations will just decrease your flexibility and choice. And with that, we thank you. As we mentioned before, if you submitted a question that we haven't answered, I think we can answer the only other question we have here. But if you have any additional questions related to today's topic, please email them to akeating, A-K-E-A-T-I-N-G, @mayorbrown.com, and your questions will be promptly forwarded to Miles or me. Miles and I thank you for all of your attention today, and we hope to provide you with some valuable considerations for the next time you are asked to negotiate a dispute resolution clause. Now, one question that is on the board before we go is somebody asked is, does the New York Convention in any way limit the arbitration rules to choose, or is that irrelevant? The New York Convention does not sanction or call for any particular arbitration rules. I'm not aware of any case in any jurisdiction where they've overturned or refused to enforce because of the failure to follow some particular rules. I will say that under the New York Convention, though, there are one way that a country can refuse to enforce if it violates the public policy of that country. There may be some potential way that a court could find around that. But the basic answer is no, the New York Convention does not in any way limit the arbitration rules. And that, I think, is it. We thank everybody again for their attention, and thanks for joining us today, and we hope this has been helpful to you.
Thanks, everyone. Goodbye.